On a typical day, police officers pull over more than 50,000 drivers. If you've had a recent encounter with police, chances are good it was during a traffic stop. Traffic stops can lead to searches, arrests, or worse, yet they seldom involve a search warrant. So how did vehicles become Fourth Amendment-free zones? I'm Kim Norberg of the nonprofit civil liberties law firm, the Institute for Justice, joined by co-host Keith Neely and Josh Windham, the leader of IJ's project on the Fourth Amendment. We'll explore how traffic stops are driving a hole through the Fourth Amendment and how IJ is pushing back. This is Beyond the Brief. The Fourth Amendment protects people against unreasonable searches and seizures, but police stop and search cars all the time. So how is that legal?
Well, 100 years ago, the Supreme Court did a very bad thing. In a case called Carroll in 1925, the Supreme Court said that police can search cars roadside during traffic stops as long as they have probable cause to believe that something illegal is in the car. And that case was about prohibition and moonshine whiskey and that sort of thing. And police thought that a car might have alcohol inside of it. The problem with this is that the Fourth Amendment is designed to constrain the discretion of police out in the field. The whole point of requiring a warrant is that a judge, not the officers, get to decide if there are legitimate reasons for going into somebody's property. And the Carroll case says, no, judges aren't required. Police can decide on the side of the road that, there are good reasons to go into a car. And that eliminates the kind of chief safeguard that we all have from invasions of our property.
So these sorts of stops are the basis for several IJ cases. Can you give us an example of one?
Yeah, I'm litigating a case on behalf of a guy named Alec, who's a Houston resident down in Texas, and he was driving on a work trip on a major highway through San Antonio down to South Texas to some oil fields where he was testing out a product that he sells. He works for an oil products company. And on his way back from that work trip, he was stopped by an officer from the Bexar County Sheriff's Office for allegedly drifting over a fog line, which is the white painted line on the left side of the highway. The officer was parked on the right side of the highway and claims to have seen Alec drifting over the left side of the highway from the right side of the highway, which I think
magical eyeballs. Yeah.
Which is sort of magical, right? But nevertheless, that's what he claims occurred. After that point, the officer ordered Alec to sit in his patrol car while he wrote Alec's warning. He said, I'm not going to be giving you a ticket. I'm going to be giving you a warning. And proceeded to basically interrogate Alec for the next 20, 30 minutes and ultimately call a drug dog to the scene, which then alerted on Alec's car. And the officers searched Alec's car without a warrant for 20, 30, 40 more minutes. The whole stop lasted about an hour and 15 minutes in total. They ransacked his car. They opened, bags. They looked under seats. At one point, an officer took a knife out and kind of pried part of his seat open. And all of that in search of allegedly illegal drugs in the car. They found nothing. And Alec was told he was free to go at the end of that. And most Americans, when subjected to that kind of treatment on the side of the highway, wouldn't do anything about it. They wouldn't file a lawsuit because Alec didn't get a ticket. There's nothing to appeal, right? And there's really nothing to do unless you're Alec and you team up with IJ and you decide, I want to set up a situation, a precedent where others aren't going to be subjected to this kind of unconstitutional traffic stop and fishing expedition. And there's a lot more I want to unpack about the traffic stop, but that's kind of a sketch of what happened.
Well, starting then with the traffic stop, they stop Alec, they ask him all these questions over the span of 30 minutes, and then they call in the drug dog. What justification, if any, has the officer offered for calling in a drug dog to the scene of a routine traffic stop?
Well, the officer said that Alec was breathing heavily. He appeared kind of nervous. Alex
seems like anybody would be nervous if they were forced to sit in a patrol car on the side of the highway.
There's case after case in the federal courts saying that it's totally normal for people to be nervous during police interactions. But the problem with this kind of legal standard is that let's back up a little bit. When police pull you over for a traffic stop, generally speaking, they have to have a stop that is confined to the purpose of the stop. So if they wrote you up for a traffic violation, for example, they have to let you go after they're done writing your ticket and dealing with all the kind of traffic-related tasks. That doesn't take more than like 5 or 10 minutes. They ask you a few questions. Where are you going? License and registration. They run your name through a computer to see if you have any outstanding warrants. And they print your ticket or warning, and you're generally supposed to be free to go at that point. There's a case called Rodriguez from the U.S. Supreme Court in 2015 that says that if police want to extend a traffic stop beyond those traffic-related functions, they have to have reasonable suspicion to think that you're engaged in some other non-traffic crime. So, maybe they think you're dealing drugs. They have to have reasonable suspicion that you're dealing drugs. Maybe they think you're transporting stolen goods. They have to have reasonable suspicion of that, right? And so under the Rodriguez standard, they needed to have some kind of reasonable suspicion to believe that Alec was engaged in a crime other than allegedly drifting over the fog line, to hold him in the car and continue to question him about drugs in his car, money associated with drugs, and eventually call a drug dog to the scene, extending the stop way beyond any legitimate traffic-related functions and ultimately searching his car. They didn't have that. Again, the officer in this case said Alec was nervous, said Alec's story wasn't lining up, said Alec wasn't giving enough details about his story. All of that is totally false. If you just watch the video that we've posted online about the case, Alec was more calm than I would have been,
Right.
And more collected than I would have been in reciting the details of his trip and saying exactly where he was going and why.
The frustrating thing about this, too, is that when you read cases about the Fourth Amendment, and specifically these types of stops, you'll see conflicting justifications across these cases. Sometimes it's they talk too much. Sometimes it's they talk too little, Sometimes it's they appear too calm. Sometimes it's they appear too nervous. Is there any unifying principle to this, or is there just blatant confusion over what can justify this sort of conduct?
I think ultimately the standard that applies here, this sort of totality of the circumstances, reasonable suspicion standard, really doubles down on and illustrates the problem with not requiring a warrant to search people's cars, right? If you give officers complete discretion in the moment to decide based on their training and experience, which is that classic line you hear from all of these cases, whether somebody is acting suspiciously, anything can be spun as suspicious. A moment ago you stuttered. An officer might say, for example, that stuttering is suspicious. They might also say, as you mentioned, that being too calm is suspicious. You'll find videos online of officers saying that people looking out a window during a traffic stop, if they're sitting in the patrol car, as opposed to making eye contact with the officer, is suspicious, and vice versa. Staring too intently at the officer somehow seems suspicious because they're putting on an act, right? So I always think of this, right? Imagine somebody just sat you in a room and watched you for an hour, right? You would do all sorts of things that anybody could come up with a story about how that is suspicious. And that is exactly what is going on in these traffic stops, where officers pull everyday Americans into their patrol cars. And literally, the officer in this case had a camera. He put his body camera on the dashboard to record our client and all of his body language and all of his answers in response to the officer's questions. So he would have a record of what he said was suspicious. Put anybody in a room for an hour and record them. They're going to act in ways that you could say are suspicious, right? We can invent stories about people however we want to. The Fourth Amendment doesn't allow, in my view, shouldn't allow police to invent those kinds of stories without the oversight of a neutral judge. And yet here we are in a situation where not only can police pull you over we can talk about the traffic violation here in a second. There's a million traffic violations out there. It's sort of in the eye of the beholder in a lot of cases, but police can pull you over for a traffic violation, find some reason to get you on the side of the road, and that's where everything falls apart, because under Carroll, they don't have to have a warrant to search your car. Under Rodriguez, they can extend the stop if they have reasonable suspicion. And so all it really takes is the officers say so from moment one until they search your car and the dog alerts, right, to get inside your vehicle and root around and see what they can find.
So in light of all this, what concrete steps can a listener take sitting in their home today to try to protect themselves against what Alec experienced?
I would say, first of all, know your constitutional rights, right? Know that you don't have to consent to anything an officer wants to do to you on the side of the road, whether that means asking you to sit in his patrol car, questioning you in his car, answering his questions, search of your car. You don't have to consent to any of that. Now, the problem, I think, is that officers, once they've decided to treat an innocent person like a criminal, like Alec, they're going to find a way to get into your car, right? And so really what you're doing at that point is you're in a defensive posture. You're just trying to mitigate the damage. You're trying to preserve your constitutional rights. You don't want to waive anything so that when you get into court, you can make some of these arguments, right? So don't consent to these kinds of requests. You don't have to. Keep a dash cam in your car, right? Like I said earlier, Alec is one of the lucky few who have a dash cam in his car who can actually show that he did not commit the traffic violation he's being accused of. And finally, if all else fails, call IJ.
So you talked about needing to have probable cause in order to search the car. What do you need in order to stop Alec in the first place? We talked about this sort of drifting over the fog line and how could he even tell. So how does a stop for, supposedly drifting lanes turn into this whole interrogation?
Well, in order to stop somebody, you have to have probable cause they've committed a traffic violation, right? Probable cause to believe someone has committed a traffic violation just amounts to, did they commit the violation at all? There may be other crimes for which probable cause is squishier, but at least in the traffic-related context, courts have said all over the country that, yeah, somebody has to commit a traffic violation for you to have probable cause that they've committed a traffic violation because it is black or white, right? For drifting over the fog line, it is, did they cross over the line or did they not, right? For speeding, it is, did they speed or did they not? There's not a question of discretion here. There's not a question of judgment. Maybe something like reckless driving is a little bit squishier, right? But at least in these sort of picayune, bread and butter traffic violations, they're largely black and white, right? And officers need to observe them in order to pull you over. Now, the standard that governs traffic stops is ultimately a standard that derives from a case called Terry versus Ohio. And because traffic stops are considered temporary detentions. And the Terry case from the 1960s says that you can basically stop somebody on the side of the road when they're walking by and, stop them and kind of frisk them for weapons if you have reasonable suspicion to believe they're engaged in some criminal activity. And again, this reasonable suspicion standard is squishy. It's in the eye of the beholder, and there's no court there looking over your shoulder to make sure that officers are not abusing that standard, right? So officers are given crazy amounts of discretion when deploying this standard. And in Terry, the officer said, look, I believe these guys are potentially scoping out a store for shoplifting, and or breaking and entering, right? So I want to go stop them, frisk them for weapons, ultimately found some revolvers and prosecuted them for, having a concealed weapon or something like that. In this situation, though, Alec was pulled over for allegedly committing a traffic violation that I want to talk about in a second. He did not commit, but for allegedly committing a traffic violation. And then we have a case sort of extending the Terry rationale called Pennsylvania versus Mims that says during a traffic stop, an officer can order you to exit your own car out of safety reasons to see, you might have a gun on your person. You don't want to have furtive movements the officer can't control happening inside the vehicle. And so it's this sort of domino effect, right? Of where, okay, now you've pulled somebody over. Mims says you can order them out of the car. Rodriguez, in cases before it, say that you can extend the stop if you have reasonable suspicion. And then ultimately, a case called Florida versus Harris says if a drug dog comes to the scene and alerts, they can search the car, right? And so this sort of check, all the way into searching somebody's car on the side of the road. All of that is made possible and incentivized by the Carroll case from 1925, which says, look, if they have probable cause to believe there's something bad in the vehicle, they can search the vehicle. That has set in motion all of these other cases.
Josh, we talked about this a little bit when you were last on the show to talk about your open fields cases. Is there any historical basis for all of these exceptions to the warrant requirement? I mean, I know with Katz and with Terry, there's kind of a lot of policy-driven analysis going on. It's not necessarily always historically grounded in the text of the Fourth Amendment. Is there any historical justification for the law as it stands now?
Yeah, I mean, the Supreme Court in Carroll tried to do a sort of historical analysis where it said that, post-ratification of the Fourth Amendment, there were statutes that were adopted by the first Congress, or first few Congresses at least, that authorized warrantless searches of ships if police had good reason to think there was smuggled goods inside the ships, right? The problem ultimately first of all, there's a couple things going on. One, I don't really think that relying solely on that kind of post-ratification history of what a Congress chose to adopt in the form of a statute about a ship can really inform how officers should be treating our cars in the 21st century, right? That's kind of the first problem. Number two, though, I think the core rationale of the Carroll case was actually that it's sort of a quasi-exigency idea. So exigency is this idea that if police have an emergency, if it's sort of a now or never situation, if they have to act or something bad's going to happen, like someone's going to get hurt or property is going to be destroyed, they can dispense with the warrant requirement in that situation. So the classic example is like there's a murderer on the loose who's just killed somebody and he takes refuge in Kim's house, and police can break down the front door without a warrant and go stop the murderer, right? That's like a classic exigency. So the idea with Carol is, okay, well, it's sort of like an exigency if police have to go get a warrant when they've stopped you on the side of the road and believe for legitimate reasons there's something illegal in your car, because if they go get a warrant, you can just drive away outside the jurisdiction. There's nothing they can do to stop you, right? Because their jurisdiction is limited. So the problem with that today is that basically every state in the country now has a procedure that allows police to get a warrant electronically. So they, on the side of the road, they can fill out a warrant affidavit on their computer and send it to judicial chambers, right? And have a judge look at the affidavit and sign it right then and there electronically. There's no legitimate reason now to think, like we did in 1925, even if that was legitimate then, that it's an exigency to have somebody on the side of the road and to think there's something illegal in their car, because police now have the tools to get a judge's approval and oversight in that very moment without the driver potentially going away.
Is that better? Like, if it's just a police can push a button and a warrant spits out, basically, is that really meaningful oversight that a judge is doing? I mean, I suppose they have the piece of paper that, you know, makes it technically constitutional, but is the actual like checking mechanism there really happening?
I mean, I think we have to assume that judges are going to do their part in good faith. They're not going to be just, you know, having 50 warrant applications on their desk coming in as PDFs and just checking all of them without reading them. I mean, I think part of what the legal system assumes at every stage of the legal system is that the people who are part of it, whether we're talking about police, prosecutors, judges, juries, all of them are doing their part in good faith. Lawyers, right? We have to assume that. Of course, there are going to be bad actors. Of course, there are going to be folks who are not doing their jobs. But then the ire should be on those folks, right? So if a judge is not doing his or her part in the warrant approval process, in the warrant review process, it is that judge's fault. And we should be directing our ire not at the officers, not at the system, but at that judge.
Did you know IJ represents ordinary people, free of charge, as they fight back against government abuse? If you're looking for a rewarding way to support our work, consider becoming a member of our merry band of monthly donors and stand shoulder to shoulder with IJ's clients every month of the year. Monthly donations are convenient and cost-efficient, meaning more of your money goes directly to our fight for freedom and justice. Sign up to donate today at ij.org/monthly.
In Alec's case, I want to take us back to the facts of his traffic stop. You mentioned that the officer's body cam footage recorded the kind of interrogation that he experienced for 20, 30 minutes. Did he have dash cam footage running as well? Did that capture this alleged traffic violation? Or because he was on the other side of the highway, is the dash cam footage just not even helpful at all?
Yeah, so the officer doesn't have dash cam footage of the alleged traffic violation, which is convenient, right? Ordinarily officers across the country now are supposed to and do have dash cam running when they pull someone over for an alleged traffic violation. Alec allegedly drifted over the fog line. You would think that if the officer observed that violation, as he says he did, while parked on the side of the highway, his dash cam would have captured that. He didn't, right? He didn't have the dash cam. It appears nowhere in the record. We couldn't find it before we filed the case. We still haven't found it. It doesn't exist. And fortunately for Alec, he has his own dash cam. This is rare, right? Most people don't have a dash cam ready to go to say, actually, I didn't commit the violation, check my dash cam, right?
Right.
It's rare to have a situation where an officer doesn't have dash cam, but the person who allegedly committed the violation does have dash cam footage. But when you watch Alec's dash cam footage, which is linked in the complaint, you'll see he's driving straight when he goes past the officer. He's not drifting over the fog line wildly or something like that. Alec is one of the lucky ones. He's one of the lucky ones to have his own dash cam and to be in a situation where he can say, the evidence proves I did not commit this traffic violation. But most people are not in that position. Most people are in a position where the officer is claiming they committed some kind of violation. They don't have a record to prove they didn't do it. And so it's just a he said, she said situation. And, we're lucky in this case to have that record. But I think one of the problem with traffic stops is that people just don't have an incentive to fight back against them most of the time. Most of the time, if you're pulled over and you're told you're going to get a warning, you're not going to do anything about it. You're not going to go to court about it. It's just a warning. Even if it's a ticket, you might just pay the $50 ticket or the $100 ticket and not even go to court. And so the problem with these kinds of roadside abuses is that generally speaking, people don't have the means or the incentive to fight about it in court. And that's why I'm glad we have a case like this, because it really does kind of hold Alec's situation up as an example of just because it's easy for police to violate your rights on the side of the road, just because it's hard to contest that for most people, doesn't mean it's okay.
So what are police looking for when we make when they make these sort of pretextual stops? Did the cop ever kind of explain what he was trying to do?
Yeah. I mean, so use the word pretextual. I think it's right to say that it was pretextual, because if you watch the body cam video of this interrogation in the car, you'll see the officer saying that actually the reason I'm out here is not for traffic. The reason I'm out here is because I'm on what's called a criminal interdiction unit. And the whole reason I sit here on the side of the road is to look for, excuse my French, big. That is a quote from the officer, not from me. He's looking at, for kilos of drugs, for human loads, human smuggling on the highway. And he's out there looking to have like a big find, right? To kind of hit the jackpot. And he sees cars as lottery tickets. If I search enough cars, I pull enough cars over, maybe I'll hit the jackpot and find that big load, find those kilos of cocaine or whatever coming across the border. That's what these officers are looking for. They're not looking for, did Alec commit a traffic violation? They're looking for what they can find inside the car after they root around. And the reason that that's, a system in place in Texas right now, I think, is because of a case called Wren. In Wren, the U.S. Supreme Court held in the 1990s that it's totally fine for police to pull you over for pretextual reasons, whether that be racial stereotyping or whether that be, I just want to get in the car, like in this case, if they have probable cause to believe you've committed a traffic violation. So as long as they can come up with some traffic-related reason to pull you over, it's totally fine if their actual animating purpose, the kind of secret purpose they have in their mind, is something totally different, whether illegitimate or legitimate, right? And I think when you have a case like Wren that gives officers the kind of green light to conduct pretextual stops, you're going to see a lot more baseless stops, right? Because if you give them an inch, they'll take a mile. And the problem, I think, is that it results in situations like this, where officers are kind of fudging the traffic stop part of it because they know what they have in their head, their secret purpose, isn't ever going to be scrutinized by a court.
Well, and this dovetails a little bit with our forfeiture work, right? Because if the officer had pulled over Alec and, let's say, searched his car and found he was carrying cash, which is perfectly legal, they could have tried to forfeit the cash, and presumably under Texas law, the government, the department responsible for the forfeiture, would have been allowed to keep the proceeds. Is that right?
That's what happens in Bexar County. I mean, Bexar County is like every county in Texas, to my knowledge, uses civil asset forfeiture proceeds to fund its own activities. So it's no surprise that you have officers kind of patrolling and roving the sides of the roads, treating cars as lottery tickets, because if they do find, $100,000 in somebody's car, and they can come up with some, like non-laughable reason to say to a court, if challenged, oh, this is actually connected to drugs, right? They can seize it through civil asset forfeiture prior to any criminal prosecution of that person. I think, a good example of that is Stephen Lara's case out in Nevada, where you have like a former military Marine who has his life savings in his car, who is pulled over for, Stephen was actually driving under the speed limit, but he was pulled over for, allegedly driving a little too close to a car in front of him, a truck in front of him. And the officer pulls him over and says, you know what? I just want to make sure that you're doing okay. I just want to make sure that, you're aware of safe driving distances, never writes him a ticket or anything like that. But ultimately they search his car and they seize, Stephen's life savings.
So what's the role of drug detecting dogs in these situations? It seems like they're involved in Alec's cases. I think Stephen's case also. They show up a lot. Why are there so many dogs?
There are so many dogs because dogs are like probable cause machines to these officers. The Supreme Court has said that a dog that is, certified by a dog testing agency is presumptively reliable when it alerts. And so officers will pull dogs out to these traffic stops on a pretty routine basis and have them, run around the car and sniff. And if they alert in the officer's view, then that is enough to search the car. There's a lot to be said about whether drug dogs are actually reliable tools for determining whether there are drugs inside somebody's car. Alec's case is a case in point because a dog alerted on his car, allegedly, and there was nothing inside the car, right? And so at least we have one situation where a guy
Right.
who's clean as a whistle has never done drugs in his life. I mean, if you meet the guy, he's the most straight edge guy you've ever met. There's nothing in his car. There's Chipotle wrappers, M&M wrappers, like a child's seat, his kids, just the stuff you would find in everyday Americans' cars. There's not illegal drugs in his car, and yet the dog alerts. What's going on there? Ask them, right? But I think at least in context where officers are pulling dogs out to the scene, it benefits them because courts pay a lot of deference to handlers' relationships with their dogs, handlers' knowledge of their own dogs' idiosyncrasies. And so there's this whole spectrum of like, is a dog alerting? Is it indicating? Is it changing its behavior in some way that suggests to the officer that maybe the dog has caught a scent of something? It's very, very squishy when you start to dig into the details of it. And courts pay a lot of deference to the officers on the ground, the officers in the field who claim to be experts in what their dog's own behaviors are and what their dog's own behaviors signify.
So what does an alert look like? Is it, every dog makes the same alert? Because I had always thought, dogs are all trained to do the same thing. If they see whatever, they, I don't even know what it would be. They bark or something, right? But it sounds like you're saying every dog has a different alert.
There's a spectrum of this, right? So to get terminology straight, there's alerting, there's indicating. Officers will talk about dogs changing their behaviors, which can sort of be a quasi version of either of those. It's sort of a spectrum of like basically how interested is the dog in this spot, right? And so like a full alert might be sitting or barking or jumping up and down. Like it's up to the officer to say what their dog's alert is, and dogs are trained to do that in different ways across the country, which is very vexing, right? For
Seems convenient for law enforcement, but
it is
difficult
convenient
for people.
And but worse than that, in my view, is not that dogs alert in different ways, because if you can establish the manner in which a particular dog alerts, maybe you can challenge that dog's alert and say, actually, no, he didn't alert. The problem is that officers will then say, well, I alone have knowledge of my dog's idiosyncrasies and behaviors, and so normally my dog doesn't wag his tail while walking around a car. But this time I saw him wagging a tail while he walked around the car. And so even though he didn't alert in the traditional sense, that change in behavior was enough for me to say he knew in his secret heart of hearts there was something in that car. And it's that kind of like tea leaf reading that really gives officers the kind of unfettered power to thrust themselves into people's cars when they bring a dog to the scene.
Has there been much, if any, in the way of empirical studies that document the effectiveness of this? Because it sounds like you point out that there's just so much room for individual interpretation here, and yet you have the Supreme Court saying that a drug dog alerting is nonetheless presumptively indicative of some sort of illicit drug activity. Was that based on empirical evidence at all? And if not, what was it based on?
No, in fact, there was a fair amount. The case is called Florida versus Harris from 2013. And there was a fair amount of information submitted by amici in that case about how unreliable dogs actually are out in the field. And the Supreme Court's response to that was to say, well, field data doesn't really matter. And a dog's record of hits and misses in the field doesn't really matter. All that matters is that a dog at some point was certified, or that a dog was at some point trained. And as long as they did well in a controlled environment, right? If they checked all the boxes in a controlled setting where they're doing controlled drills with controlled trainers, right? If all of that is fine, and kind of like imagine a lab, right? If it works well in a lab, it works well in practice. I'm pretty skeptical of that. I think for
So am I.
Yeah, I mean, one example is the dog in this case, right? I mean, even if the dog in this case was certified, he alerted on Alec's car, allegedly, and nothing was found. Like, that sounds like a dog with problems to me.
So let's go back to the case. You've talked about, the traffic stop itself was a problem. Extending it in all of these different ways is a problem. The dog is a problem. So what do we want a court to say here? We're going to roll out this whole list of, at every single point along the way, it was a constitutional issue. If the court says, yeah, we agree with you, the traffic stop was an issue, nothing else matters, or, do we want them to go through and say, yes, every single part of this was a problem? It seems like that's a very uphill battle, I guess is what I'm saying, because there's, sort of a Supreme Court precedent for kind of every single one of those things. So how do we do this in court?
Well, I think the case is all about recognizing that even though the Carroll case from 100 years ago kind of set everything off course and gave police way too much power over us on the side of the road, there are still limits, right? And so the Wren case from the 1990s doesn't say police can pull you over for no reason. It says they have to have probable cause that you've committed a traffic violation. Even if it's pretextual, they have to have probable cause for a traffic violation. And so we say that has to be a meaningful limit, right? Is there probable cause or is there not probable cause, which boils down to, did Alec commit a traffic violation? We say no, right? So that's the first part of the case is, was a traffic violation actually committed? Then you go to the next part. So officers can only extend a stop if they have reasonable suspicion, right? That has to mean something, right? And it does mean something. They have to have objectively good reasons to think that you are engaged in criminal as opposed to non-criminal travel or activity, right? And so we say, look, Alec was acting the way every ordinary American would act if they were innocent, right? And Alec was innocent. He is innocent. And so the extension of the stop violated the Constitution as well, and so on. And so, yes, it's true that, trying to prove our case at every step is harder than just trying to prove one of those things. But I think it gives us a better shot because we've got multiple points along the way where we can say officers did violate clearly established constitutional law.
So it seems like there's just in general been kind of this hollowing out of the Fourth Amendment. What is IJ doing about that? We have Alec's case, but, what's going on more broadly?
Well, Alec's case, I think, is a good representation of what the Fourth Amendment project here at IJ is all about, which is taking some of these big loopholes in the Fourth Amendment that affect huge areas of American life and trying to close those loopholes, right? And so part of the problem with traffic stops is that courts are too deferential to what officers say on the side of the road, and the standards are not enforced as consistently as they should be, right? Probable cause has to mean something. Reasonable suspicion has to mean something. Alec's case is about shoring those things up and holding officers accountable when they violated those well-settled constitutional standards. But beyond the traffic stop context, beyond the roadside context that any of us traveling on the road could experience any day, driving to work, we could have experienced what Alec experienced. That's what the case is trying to highlight. We've got our open fields cases that Keith alluded to a second ago, which have to do with government officials entering people's private land all over the country and roaming around without a warrant and spying on us. We say that's unconstitutional. And so we've got a series of cases in states like Tennessee, Pennsylvania, Louisiana, Virginia, challenging the open fields doctrine under state constitutions and saying, look, government officials should not be allowed to enter our properties without a warrant and roam around. And an IJ study released earlier this year found that about 96% of all private land in the country is subject to invasion under the open fields doctrine. And so we're trying to dramatically shift those numbers, right? This is a huge area of American life, rural, private land everywhere that is affected by this. We're trying to close that loophole. And just one more I'll give you an example of is warrantless business inspections. The Supreme Court has said since about the 1960s or 70s that the decision to enter a heavily regulated occupation or industry is itself enough to dramatically lower your expectation against government searches, warrantless government searches. And we say that doesn't make any sense. American or economic activity is as American as apple pie. It doesn't make any sense to say that the choice to work, the choice to have a business, the choice to enter a regulated field, regulated though it may be, means that you're somehow waiving other constitutional rights. That makes no sense. And so we're trying to close this idea that, okay, just by entering a regulated occupation, something like taxidermy, right? In Ohio, where we had a case, game wardens were entering a taxidermy shop of our clients and rooting around without a warrant. And the government's position was, we can do this because you're a taxidermist. His position is, taxidermy isn't even regulated. All you require is for me to have a permit and keep some records. And therefore, you can come in and root around my property and open cabinets and open drawers and look in ceiling tiles and pull meat out of freezers because I chose to be a taxidermist. That's crazy. That's un-American. And that's the sort of thing we're trying to close.
Well, this was a great conversation, Josh. Thanks so much for coming in and talking with us. And folks in the audience should check out our Fourth Amendment project.
Thanks, Kim.
Today's video focused on how police can search your car without a warrant under the federal Constitution. But many state constitutions provide more protection against these kinds of roadside abuses, and yours may be one of them. If your car was recently searched without a warrant, even though you did nothing wrong, please click the link below and tell us your story. We'd love to see if we can help. Our last episode was about occupational licensing and speech, so let's take a look at a few questions. At Family Speak Up writes, as a licensed plumber in my state, I also provide an online service where I help people with their plumbing projects all over. It's something that concerns me. Well, thanks for the comment, Family Speak Up. I think you provided a great example of the difference between speech and conduct. fixing someone's plumbing problem by going in with a wrench is conduct. Helping someone fix their own plumbing problem by giving them advice like you do is speech, even if the advice is technical and derived from your expertise as a plumber. The First Amendment doesn't protect what you do with your wrenches, but it definitely protects the advice you give. At Kupfer writes, how does the First Amendment in the U.S. interact with safeguards against fraud and defamation? For example, fraudulent nutritional advice. There are a handful of historically recognized exceptions to the First Amendment, including exceptions for defamation and fraud. These are categories of speech that have been treated as unprotected since the enactment of the First Amendment, and so can usually be regulated without raising First Amendment problems. That said, it's important to recognize that these are narrow exceptions. Fraud at common law covered only knowingly false statements of fact that another person relies on and is injured by. So, fraud would cover claims that the speaker knows to be false. In the context of nutritional advice, it would be easiest to apply to statements concerning credentials. A speaker who claims to have a state license when they do not, for example, is engaged in fraud. But it will rarely be the case that advice itself is fraudulent so long as the speaker sincerely believes it. This means that unorthodox dietary advice typically cannot be subject to regulation as fraud. And our common sense experience confirms this, because there are tons of books giving a wide array of unorthodox and conflicting dietary advice. There's no reason under the First Amendment why one-on-one advice should be treated any differently. Astaroth writes, licensure inevitably leads to overpriced, gilded, lazy mage towers full of preening lords burning every ladder in the land to ensure their fiefdom can never be burdened by change or competition. Nice medieval wordplay there, Astaroth. Like feudalism, the needless licensure of common professions, including professions built on speech, burdens the many for the benefit of a select few. Paul Kopp writes, the purpose of any organization, be it governments or corporations, is to protect itself from competition and enlarge itself and its sphere of influence and power. Increasing legislation and regulation is one way of protecting itself from competition and at the same time increasing its own power by limiting the growth of competition of others. Well, that's a great point, Paul. What you're describing is called regulatory capture, where the process by which government regulators are co-opted by the very business interests they are supposed to be holding accountable. Those business interests, in turn, use the government's regulatory authority to protect their businesses by making it harder for competitors to enter the marketplace. Whether it's cosmetologists who push for burdensome licensure requirements on competing braiders, or brick-and-mortar restaurants who try to restrict competing food trucks, regulatory capture leads to economic protectionism that hurts consumers and violates the Constitution. That's why we at IJ work so hard to fight back and protect a person's right to earn an honest living. Healing Swordsman writes, occupational licensing is sometimes required, though. I don't want a random person designing buildings, for example. Even advice that is for medical disclosure is absolutely vital. Otherwise, you're just being irresponsible. There may be an argument for occupational licensing when it comes to potential harms to non-consenting third parties. A person who enters a commercial building, for example, trusts that the building is not going to fall down, and the state can set reasonable requirements for who may certify that a building design is safe. The problem is that outside of the non-consenting third-party context, states tend to use occupational licensing as a first resort rather than a last resort, ignoring viable alternatives like voluntary certifications or disclosure requirements. For example, rather than banning unlicensed people from giving dietary advice, states could require unlicensed speakers to disclose that they are unlicensed. Even less burdensome would be to make licensing voluntary and simply prohibit unlicensed speakers from falsely claiming or implying that they are licensed. It will rarely be the case that advice is so potentially dangerous that a speaker who truthfully discloses her credentials should be prohibited from even uttering it. 5-Star Dave writes, what about regulating speech versus regulating the sale of speech? The First Amendment makes no distinction between speech that is sold and speech that is given away. And if you think about it, that has to be the case. It couldn't be that the First Amendment protects the distribution of Plato's Republic as long as it's given away for free, but ceases to apply once the book is sold. and numerous decisions of the Supreme Court confirm that a speaker is no less a speaker simply because he is paid for his speech. Thanks again for watching today's episode. Make sure to like, subscribe, and watch next time.